WDXE.
The legend WDXE, that's us. And of course, we're live now with Stan Pierchoski, Pierchoski Law and Estate Planning. Estate Plan Stan, better known as. How about that?
Good morning, Jeff. How are you?
Good morning. How are you?
I'm doing very well,
Very
considering
good.
the heat, but hey, it'll come to an end here before too long.
Well, yeah, maybe we're going to get a break next week. It looks like it's going to come back down on us a little bit. But boy, the heat has been something to talk about, I'll tell you.
I mean, it is August in Tennessee, but still, it's a little bit on the high side for what we're not used to get. But
Yeah, it's so muggy. That's
it
been-
is. You just got to be smart about it.
That's
know?
right.
You don't get out there and just say, "Well, I'm just going to power through it," because your body will shut itself down whether you want to power through it or not.
That's right. Take your precautions, that's
Yeah,
for sure.
that's right.
Well, it's been a whole week since I've seen you. You had a
has been.
busy week.
Seems like it's always a week between when we see each other.
Yeah, it kind of works that way, doesn't it?
It sure does. So yeah, we had a busy week. Actually had a couple of 10-care approvals come in on cases we had. So that's always good news when it happens in the office. We
Yeah.
like to deliver that to the family and say, the loved one's been approved, and the strategy that we used was successful. And we're 100% successful in eligibility. We never failed to get anybody eligible yet. So
Well, that's very good.
sometimes we get handed some difficult situations. The most difficult situations we get is when some folks will try to do a do-it-yourself application, and then
Yes.
it gets denied, and then they come and we sort of in fix-it mode, which is a little bit more difficult. But we can always recover. We just analyze why they denied, just dig back into it, fix it, then reapply. Once we got things fixed, and then we usually get eligible.
Yeah.
So that's the trick. But the best thing to do is to get it that way the first go-around,
Yeah, absolutely.
and get eligible then. So, speaking of eligibility, we've been talking a little bit about this crisis planning. We kind of
Yeah.
bounce around topic-wise, but the main focus was on crisis planning for a little while. And I was talking a couple weeks ago about these things called divestments. And I get asked, and the reason I go over them so much is because I get asked about them all the time. And a divestment is when you give something away. When you give something away, they're going to punish you for giving it away during the eligibility process. I mean, you can, like I said many times, you don't get confused. You can give stuff away. It just depends on when you give it away, whether it's going to be an issue. And if you give it away, but you need to know what goes along with that. There's a little bit of baggage that goes with it. So we always talk about giving stuff away in this 5-year period prior to applying for 10-care benefits. If you do, they're going to impose this penalty period. And there's all kinds of divestments. It's just not as simple as you writing a check and giving somebody that is like, $10,000 gift. That's certainly a way. Giving away real estate, that happens a lot. But, I talked about underselling and overbuying. I talked about, you have a $20,000 car and you sell it to your child for $10,000. Okay,
Yes.
They're going to call that a $10,000 divestment, a gift, because you undersold it for fair market value.
Correct.
Same thing if your child has a car for $10,000 and you pay $20,000 for it. They're going to consider that $10,000 of that a gift because you're giving. You're not. It's not a fair market exchange quid quo pro.
Sure.
Arm's length transaction. We talked about joint ownership of property can be a divestment. If you just make somebody, you have a $100,000 bank account and you make somebody a joint owner of it, you're literally giving some away, or especially with real property, with land. Bring somebody in. There's quite a few. We talked about several other things, but a couple of things I want to talk about along those lines that people do, and it's the divestment part kind of hides in there, and it's not so easy to see. And it seems to be becoming more and more popular. Now, I'm not a fan of these strategies, but there are a lot of people doing it. And I think if you're going to do it, you need to know what goes, like I said, what goes with it. It's not always just that cut and dry. One of them is like when you assign income. If you have income and you choose to take less of it,
Right.
That if you're voluntarily giving some of it up, it's called a divestment. A classic example came out of a case. It's another state, I think it was Illinois, where a woman who was receiving alimony or spousal support. It was like $2,100 a month, and she agreed to take only $1,500. And when she applied for Illinois' version of Medicaid, they said, well, that's a divestment of $600 a month, and they went to court, and the court said, yeah, that's exactly what it is. You've agreed to give that up. And of course, the presumption is if you give something away, it's for purposes of eligibility.
Sure.
And there's a thing called disclaimer. We talk about inheriting property a lot, whether it's by will or by trust, it doesn't matter. But if you're going to inherit property, you have an absolute right under our estate laws to disclaim the property. You can say, I don't want it. Okay. There's reasons why people don't want it.
Yeah.
Sometimes people live in, Colorado, and they inherit a piece of property here in Tennessee, and it's like, I don't want to own a piece of property in a state that far away and have to deal with it. I don't want anything. And if you could sell it, of course, but you could say, I disclaim it. I'm just not refusing taking it, because you can't make somebody take a bequeath.
Yeah.
Can't force it on them. So you
kind of hard to imagine someone would turn it down, but I guess there's circumstances where they do.
That's where we're going on the circumstances why people would. And when you turn it down, it really is. You're treated. It's called a disclaimer. If you disclaim the asset, it gets distributed as if you predeceased. So if it says, okay, I'm going to leave this property to Stan, but if he's predeceased, it goes to his 3 children. So if I say, hey man, I don't want it, I disclaim the property. Well, it passes through me and goes. That's the way it gets distributed. But the important thing is if I disclaim it for purposes of eligibility. Let's say you're trying to get eligible and Aunt Gertrude leaves you $10,000 and you're thinking, I appreciate Aunt Gertrude, but right now I'm trying to get qualified for my long-term care, which is a bigger ticket item in the grand scheme of things. I'm going to disclaim and say, okay, I don't want this, therefore, because it's going to mess up my eligibility.
Yes.
You disclaim it. Well, that's considered a gift. You're giving it essentially to the people that it passed through to you. You're entitled to it. And the way that TennCare looks at it is that's money that you could have used for the cost of care if you'd not given it away or not disclaimed it. Okay. So there's debt forgiveness. Sometimes people will, especially with children, they'll loan them $50,000. And there's an agreement to pay back. And let's say they're paying back, and they get halfway through this debt, and they still owe $25,000. The parent's trying to qualify for TennCare. You own this debt. That's an asset. It's a $25,000 asset. You own the right to receive these payments. And they say, well, this is going to get in the way, so I'm just going to forgive the debt. Call it null.
Uh-huh.
Well, that's... think of it this way. When we talk about these divestments, anytime you part with something for less than fair market value, essentially for less than what it's worth,
yes,
it's going to be looked at as a gift. So that's considered a gift. Now, the ones I wanted to talk about today are gaining more popularity, and it's not a favorite one of mine. I get the concept, but I don't like it because it's hard to make it work. But have you ever heard people that have been married for 50 years, 40 years, 60 years, a long time, and one of them needs to be in care,
yes,
which is a common scenario so far.
Yeah.
One of them needs to be in care. So there's a theory where in order to get qualified, because they own a lot of assets, they will divorce. Okay. Now, they're not divorcing because they don't like each other, can't get along, and hate each other and just want to go their separate ways and get back on the dating scene, right? Mm-hmm. They divorce for the sole purpose of this eligibility process.
Interesting.
And what they'll do is they'll divorce, and they will the settlement of property. Because when you have a divorce, the only thing you really discuss are kids and the property. So usually folks going in nursing home don't have minor kids to deal with. So it's the property issue. And so what happens is the institutionalized spouse, the one that's in care or trying to get eligible, will agree to very heavily let the other spouse have most of everything.
Yes.
For the divorce. And that theory is, I don't have anything, therefore I don't have to worry about transferring my assets or converting my assets from countable to non-countable. I'm getting nothing out of the divorce. So all these assets that were in the way during this calculation we do, a few weeks ago I talked about calculating what we call the community spouse resource allowance for married people, where we kind of divide everything in two and say this is your half and this is your half. If you're going to let it all go in a divorce to the healthy spouse, the theory is we don't have to worry about that because we're not retaining any of that.
Yes.
Now, the trouble with that is if you go into court and the court divides property, the statute says, so if you have a contested divorce, mm-hmm. you can have a contested divorce, which is a real knock-down, drag-out, or you can have a divorce by agreement or irreconcilable differences.
Sure.
Now, if you have a contested divorce, you have a hearing, and the judge decides things. He decides who gets the children when, and he decides who's at fault and how much alimony is to be paid, if there's any to be paid. But one thing the court is charged with doing, and the statute says they are to provide an equitable distribution of marital property.
Yeah.
Okay. Now, marital property is what we're talking about, and it's got to be equitable. Now, we're not a community property state, so it's not a 50-50 split. But when you've been married for 20, 30 years or more, and most everything is joint, it's kind of in that ballpark. I mean,
Sure.
it just has to be. And so the judge decides and splits it. Now, if you had a situation like that, there's no divestment. I mean, the judge said this person gets this, so the half that goes to the healthy spouse is no longer available to you. And you get what the judge says you get. The problem has these people, the judge is never going to give everything to the healthy spouse and make impoverishment for the sick spouse.
Yes.
Because they have this duty to do an equitable distribution. Unless there's some reason, which I struggle to find a good one. But now, what happens with most folks is they enter into an MDA, a marital dissolution agreement, which is an agreement amongst the parties. And the parties agree. I mean, this is very common. MDA is how we're going to divide the property. We don't want to go to court. We're just going to talk among ourselves. You get this, you get that, you get this, you get that. Now, that does not have to be 50-50. It can be however you guys decide to do it. And the court will prove it. Because if the parties agree, why does the court care? As long as it's equitable. And the court will ask you, do you feel like this is an equitable division? Even if it's 70-30.
Yes.
The person with 30% says, yes, if I feel like it's equitable, then I'm okay. And so the court will sign the MDA. Now, what TennCare will do is they'll say if you divide it heavily in favor of the healthy spouse, you have done that by agreement. And maybe you see where I'm going. You have consented to giving up what you could have gotten if you've gone to court and the court divided it equitably.
I see.
And they're going to say, in that case, what you've agreed to give up is considered a divestment. Just like that alimony case I said. The gal was entitled to the court ordered $2,100 a month alimony. She made an agreement outside of court with her ex-spouse to only receive $1,500. And they said, you agreed. It's as much as if you just got the $2,100 and took $600 and turned around and gave it away. So you agreed to not get it. And we're going to consider that a gift or a divestment. So same thing with the marriage thing. So the marriage, getting divorced is a tricky strategy. It's hard to make it work. I don't like it. There's so many other good ones that we can use. So, I mean, if you heard about that and you're thinking about it, let's think about it more and talk about it more and get it all laid out as what all you're going to be dealing with. Because there's nothing worse than going through that, applying for TennCare, thinking everything's, right the way you want it, and then get a big old denial from them because of being over-resourced, and they're going to cite because of this, we're not recognizing this equitable division, we're recognizing it as a divestment, and therefore you have a penalty period because you've given this stuff away. I mean, that's a bad day to get that bad news in the mail. So the next thing I want to go over is it's called a just say no strategy. But before I do that, I want to remind everyone that this show, Bulletproof Estate Planning, that we do every Friday from 8 to 9, is a interactive show.
That's right.
So if you're listening to this and you want to call and ask me a question about what we talk about, or maybe not exactly what we're talking about today, but something I have talked about, or something that you've thought about or heard, folks in this boat that do estate planning or do elder law planning, think about this stuff. They go on the internet, they get way too much information. So if you want to call and talk about anything along those lines, feel free to call in. The number is it's 931, of course, but it's 766-9393. Pretty easy number to remember. I always struggle with 762 versus 766, but I know if I don't get it the first time, I'll get it the second time.
That's right. 766-9393.
That's right. So if you want to call in, feel free to do so. I encourage questions. I really enjoy the questions. So, but there's another strategy among spouses. It's another one that has some hidden effects to it.
Okay.
It's got the name of just say no, but basically what it is, you have a married couple. Let's just say my wife and I. And my wife has to go into long-term care. Well, I said several weeks ago that when you're a married couple, one spouse of a married couple goes into care, they look at all your assets collectively. everything my wife owns in just her name is collective. Everything I own in just my name is collective. And everything we own in both our names is, of course, collective. So they put it all in the same pot, which is why it doesn't do you any good to put stuff in your wife's name or your husband's name before they go into nursing home, because when they do this calculation, they're just going to put it in the pot anyway.
Right.
There's a time to do that, and before application is not the time. But so if she goes into nursing home, they're going to look at everything we own. And let's just say I do have some assets in my name. And when they want to do this, I just say, you know what? I'm going to refuse to participate in this process. I refuse to use any of my assets to pay for my wife. Now, it makes me sound like a real dirtbag, and I'm just using it for an example.
Yes.
And then when people that do this, it's not, they're doing it for this strategy. You know, they're not doing it because they just refuse to pay. They're doing it to try to save assets.
Sure.
And so, and it can happen. If you refuse to participate to the extent that they can't determine what the marital assets are, then they're forced by the law to treat my wife as a single person. Okay. Now, when they do that, that has the quasi effect of not incorporating all the marital assets into any kind of spend down technique. Okay. So that people think they're saving a lot of property by doing that. Now, what happens though, they're not going to not take care of the sick spouse because the other spouse refuses. And this is kind of the whole theory. You can't fault the one that's in care for the, I guess you call it dirtbag spouse that refuses to help. Right?
Okay.
Okay. So the law can't fault that person. But when you do that, you open yourself up to civil suit by the TennCare. And they can go sue that spouse civilly for his participation in the marital unit. Okay, now they're not getting divorced; they're still married, so there's that tie.
Sure.
And I think you remember a court case I covered several weeks ago about just that the court said an old common law doctrine says a married person is responsible for their spouse, so they have the grounds to sue, and they do. I mean, they do go after that.
Yeah.
It depends on, TennCare is a money game, a numbers game. So if it's not very much, they kind of don't. It's not worth it or equitable for them to go after it. But if there's something there, and of course the only reason people do it is because there's assets to protect.
Right.
If you don't have anything, then there's no reason to do the just say no strategy.
Right.
You don't have anything to lose. But if you have assets, you want to protect them. If it gets their attention, they will come after you and sue you. Now that's a bad day too, because you have a difficult defense when that comes around.
I bet so.
It's hard to be successful. So these are things I hear, and I don't know where they come from. They're not really strategies that come from the law. We deal with these strategies we talk about. They come from our spousal impoverishment rules that come out of the Deficit Reduction Act of 2005, the Catastrophic Illness Act, the TennCare Act. These are all strategies that I talk about that we do are founded in statute, founded in law. The divorce and the just say no are kind of, they don't come out of that. They come out of like this concept of putting assets somewhere else, and so it's kind of homemade in a way. But
Sure.
It's gained a lot of popularity, so I hear a lot of people ask about it. Now, if you ask me about that, I can tell right away the reason you're asking is a little bit of desperation. You're looking for a way to not lose your stuff, right? I mean,
Right.
And I get it. I don't blame you. But again, if you do that or you hire somebody and they want to do that, be sure it's explained very clearly to you. It's kind of like a reverse mortgage. They sound really good up front, but if you know you don't have the house anymore at some point, especially at death, that may or may not be what you want.
That's right.
It can be a fit, but usually the fit is a little more the exception than the rule is what I've experienced.
Yes.
So those are just a couple strategies I wanted to bring up that have come up, over the, I mean, they come up all the time, but it seems like recently they've come up a lot. I had a couple of those very questions last Saturday when I had my Franklin seminar. Mm-hmm. Oh, we had a great turnout up there.
Good.
It's not as big as WLX here. The next one we're doing is September the 16th, which is a Saturday, and that's going to be here, WLX. And the Country Cafe back here, right here on the other side of that wall, I believe, is a big venue. We can house a lot of people there.
Yeah, that's a great venue.
The place we were at was capped at about 50, or at least tables and chairs. There were some other chairs we could have brought out, but you wouldn't be sitting at the little tables they have there. And I think it's capped at 50. And I think we had one or two empty chairs because we had a couple people that said we would have been full, except there's a couple people that called said they couldn't make it
Sure.
at the last minute. But we had a packed crowd, and I got a couple of those questions. There was some elderly couples there that were considering this divorce concept. At least they were smart enough to not jump into it and ask about it.
Sure.
You know, so we talked about it, and we set up an appointment and talked about it at length. Now, again, it's hard for me to find a good reason why that one works, but I guess there could be, you know, because some folks do it. But I'm seeing more and more of those things go to court, too.
That's interesting.
Yeah. And it's here's the thing, just about anything you can think of to hide your money
Yeah.
or keep them from getting it has already been thought of.
Yeah.
And a lot of it before the ink was even dry on the Medicaid Act back in 1964. I mean, this is nothing new under the sun.
Right.
All right? And so there's a good way to do it. And there's I say all the time, you know, we can protect, if you're married, I can protect 100% of what you own. If you're single, most, 50 to 70%, which is still better than nothing. But we can do that. But we do it with legal means. You know, we don't hide the assets. I mean, we protect them.
Right.
And when we do stuff, it's fully disclosed. You know, like I said, we got 2 approvals in this week. And when we do these 10-care applications, I mean, we lay it all out. We tell them exactly what we did.
Right.
And they may call us and say, I see here that you, in your checking account, $200,000 left. Where'd that go? And I'll say, well, we put it into, we bought a Medicaid compliant annuity with it. And they say, oh, okay, so you turned it into so it's not countable anymore. You turned it into a non-countable stream of income. I said, that's right. You know, they say, okay, we understand. Or they'll say, I see you gave $500,000 into a trust. When did you do that? I said, well, 6 years ago. They said, oh, okay, so it's out. We can't impose a penalty period now because it's more than 5 years. That's correct. You know, so they know how all this works.
Sure.
They're looking to see if you did it wrong.
Yeah.
I mean, when I talk to them, you know, you can put property in a trust. They know how they work. They don't mind it a bit. But they'll want to see the trust because they're going to look at it and say, I'm going to see if the maker of the trust had access to principal. Remember, we talked about that.
Yes.
You know, if you do, remember I said the thing to memorize, if you can get at it, they can get at it. So that's what they're looking for. They don't mind the trust. They know how it works. They're looking to see if you screwed it up or the person that wrote it for you screwed it up. And if they find access in there, they're going to say, you know what, I see where you had access to property in this trust.
Yep.
So if you have access to it, therefore we have access to it. We can consider everything in this trust countable. And I know just where in the trust they're looking for it. I mean, I write the thing. I know exactly what they're looking for. When they read mine, they're not going to find it because I know how it works. I know what the courts will support. We disclose everything. You know, did you ever give anything away for less than fair market value? Yes. When? Yesterday. Okay, so that's going to trigger a penalty period. Yes, we know, and it's 7.5 months, and we fully understand that.
Sure.
And we use some other money that you'll see to buy an annuity to pay through that penalty period. They'll say, okay, I got it. I mean, everything's above board. We don't hide anything. When you hide it, it's a problem. Now, I get a lot of people that tell me they got some gold or cash in a safe or buried in the backyard. No, I'm not saying don't do that. I mean, as an attorney, I have to say, don't lie about it. Don't ever fill out an application and say, if it says how much money do you have, and it's a question you're supposed to answer.
Yeah.
Don't give them a false answer because that's always actionable. But I get it. You know, my dad said to me, my dad had an interesting concept of inheritance. I think it came from in his family, and he said, if I just bury my money in the backyard, there's a shovel in the garage. When I'm dead, go dig up your inheritance. And it's like, well, why wouldn't that work? I mean, it probably worked for centuries. Now, so when people say, I've got this gold or I got this cash in my safe that nobody knows I have, so if is a nursing home ever going to find out that I have it? The answer is, I don't know, probably not. But here's where that could be a problem. So, I mean, like I said, I can't advise people to say, yeah, hide it, put it in the safe. Sometimes they'll reveal to me that they have it. And I say, here's where that can cause a problem. If, let's say, you got, $50,000 hidden in a safe, buried in the backyard,
right,
stashed somewhere. And so you or your spouse go into long-term care. And when you go into long-term care, you have to fill out a pretty extensive income and asset table of what you have. Because you have to become eligible, and you become eligible on what you own, and so you have to disclose what you own. Now, if you don't disclose this hidden cash, which the whole idea of hiding it is to not disclose it. Now, the next thing that has to happen is, well, first of all, you're not disclosing it, and let's be honest and talk about where the rubber meets the road. And if you say you don't have it, you are saying you don't have it intentionally, right? You know you have it, and you're saying you don't.
Yes.
That's the beginning of the problem. Second problem is if they ever find out about it. Now, how can that be? Well, somebody with a big mouth. It could be a purchase you make that kind of comes out of money where nobody can figure out where, if they find out, now you are flirting with TennCare fraud because you've just defrauded them by saying, I'm applying for benefits, I qualify but you didn't disclose this asset. That's, and that's an under oath thing. So now, would that happen? I don't know. Never seen it happen, but it sure could. I can sure see what could happen. And you know how it is. You probably couldn't keep a secret in this room. Now, I don't mean to be insulting to you, Jeff, but I'm saying people that want to keep secrets like that, you know as well as I do how that works. It rarely does.
Rarely does. That's correct.
Even if it comes out innocuously or very innocently, it usually comes out somehow. So again, you might make a purchase out of this money with something, and if that, depending on what it is, and you got a paper trail, and I don't, this day and age, it's hard to buy or sell or trade anything and not have some kind of trail.
Yeah,
it really is difficult. So that's where I think is a problem. I don't say do it, or I don't say don't do it. But if you do it, if you're going to go through this process, I need to be honest about it because that's what the law requires.
Sure.
So anytime you're dishonest about something, it's a potential problem.
Absolutely.
So it's not a good way to be.
Absolutely.
Anyway, we talk about these. We talk about those divestments, and then one of the next things I want to move into is how to make these divestments work in our favor, because there are ways to do that. When you have a divestment, it triggers a penalty period, or if you have a divestment, we might want to make it not trigger a penalty period. And so remember, let me go back to basics, because as I talk about this Friday after Friday, maybe you hadn't heard one or lose track of why we're even bothering with this. When you give stuff away, the problem with a divestment is they can't come and take it back. It's a good example is real estate.
Sure.
If you just, so a lot of people come and say, well, I want to give this to my kid, but I'm worried I can't give it to him because it's 5-year look-back rule.
Right.
It's like, well, wait a minute. No, you can give it to them. It may trigger the 5-year look-back rule, but you can certainly give it to them. That's a way to get rid of property. It's not always the best way, but it certainly is allowed. So if you give property away, the big factor is when it's a problem is when you gave it away.
Yes.
If you gave it away more than 5 years ago, everything's fine. It's a divestment. It's cleared the penalty period look-back rule. And so there's nothing they can do about it.
Sure.
But let's say you give it away, and 2 years later, we're applying for TennCare. We're in our 5-year period. And it's like, oh, no. They say, oh, see, I see where you gave this piece of real estate to your son. And they're thinking, uh-oh, my son has borrowed $200,000. He's built a house on it. He's made improvements. He's been living there all this time. Are they going to come and take it away from him because I gave it to him for nothing? The answer is no. The moment you gave it away, you made it non-countable. You made it so they cannot get at that property. Mm-hmm. It's gone, right? You've gifted it away. So if they're mad at you, it's like, hey, I don't have it. It's not mine anymore. I gave it to my kid. When I gave it to my kid, ownership was complete. I deeded it to him. I couldn't get it back if I wanted to. If I wanted to get it back, it would require him giving it back.
Sure.
So I am powerless to give it back. Well, this is what the 5-year look-back's all about. They can't go take it from your child. They don't have the jurisdiction. And they can't make you give it back because it's not yours to give back. What they can do is punish you for giving it away if you gave it away within that 5-year period.
Yes.
And they do that by saying, okay, what was the value of the house when you gave it away, divided by our Tennessee divestment penalty divisor, which is about $7,100, and it come up with 30 months. And we're going to say, okay, because you gave it away, and because we can't take it from your son, and because we can't make you get it back, and you gave it away, and if you'd have kept it, you could have used it to pay us, we're imposing a penalty period based on the value of what you gave away, where we're not going to pay. So you could fill your application out, send it in, and they would say, you're eligible. Stan, we got your application. We evaluated everything. You're eligible. We are ready to pay your $8,500 a month. Mm-hmm. But we're not going to pay for 30 months because you gave this piece of property away in the last 5 years that was worth about roughly $210,000. Now, as soon as that 30-month period expires, the very day it's over with, we'll start paying. But we're punishing you for giving that away. Basically because that's all we can do. We can't come take it from your kid and sell it. we don't have any jurisdiction. We can't make you give us something you don't have, but we can deter you from doing it in the first place by posing this penalty period. So can you give it away? Absolutely. And when you give it away, remember we talk about countable and non-countable?
Yes.
The moment you give it away, it is non-countable. They can't get it because they're only interested in countable assets. So that's part of the strategy works. The problem is we have now opened up something in the 10-Care Act that allows them to impose this penalty for the next 5 years. Mm-hmm. There's a big difference between the two. It doesn't mean you can't give it away, and it doesn't mean that won't work. It doesn't mean they can't get at it. You know, some people will. There's a strategy where if we have property, we absolutely, positively do not want long-term care to get. Mm-hmm. We want it to stay in the family. We want it to go to the kids.
Right.
We absolutely don't want to take no risk of that being lost. Go ahead and give it away or put it in one of these trusts. Because when you put it in one of these asset protection trusts, it's the same as giving it away. We're giving it to the trust. But it's our trust, and we have control over it, but it's still giving it away.
Right.
The moment we put it in that trust, or the moment we give it to the other person, they can never get it. We've accomplished that goal. Mm-hmm. The problem is with this penalty period, because of when we gave it. Now, if it's something we absolutely want to give away and nursing homes coming down the pike in 5 years, well, now we just live with the penalty. And we try to make the penalty, we try to mitigate the effect of the penalty. So we accomplish the goal.
That was going to be my next question.
We're just going to live with the penalty.
Okay.
You know what I mean? So, or mitigate the penalty.
So how would that look?
Well, here's a good example. Well, let me see if you want to live with a penalty and mitigate it. Let's say we do exactly that. We put our property into a trust, and the trust is the best way. If you just give it to your child, mitigating it is kind of out of the equation. You are just stuck with the penalty.
Yes.
You can't do anything about it, unless your kid's going to help pay your bill. But that's don't know. But if let's say you give this property to the trust. Let's take that $210,000 house I'm talking about. I use that because it's a number that divides easily into this. If you round the penalty divisor to 7,000, I mean it's nice, easy. Gives a 30-month penalty period, right?
Right.
So I put property into this trust, and it's protected the moment I put it there. They can never get at it. But what they can do is punish me if I go into the nursing home in the next 5 years. Mm-hmm. By not paying. And the penalty is going to be 30 months because it's going to be $210,000, the amount I divested myself of, divided by the Tennessee Divestment Penalty Divisor, which is $7,090.20 per month. So if you divide that out, the dollar signs divide out, and you get an answer in months. That's the engineer in me, sorry. But and around the 7,000, I round it off to 7,000, so you can do it in your head. So you get about 30 months. And that's the penalty period. So let's just say that house was something. It's been in the house. It's been in the family for years. It's a family. I don't know. You can't call a house an heirloom, but you know what I mean. A legacy. Right. It's been in the family. We want to keep that house. It has so much sentimental value. We want to keep it forever. It's been in the family forever. We want to keep it forever. So we put it in this trust to protect it. The moment we put it in the trust, long-term care is never going to get it. But they might hammer the person who put it in there with a penalty period.
Sure.
And so let's say it's me. I put it in there, and they say, and I know the day I put it in there, I've got this 30-month penalty period. Mm-hmm. And that 30-month penalty period doesn't even start. People say, well, does that start the day you put it in? No. That will start the day I apply for 10-Care. Okay. That was part of our Deficit Reduction Act is when this thing starts. So, but we start thinking of it the day you put it in. It was like a look-forward period. So if I put it in, and it's in there for a year, I'm thinking, okay, if I apply now, I'm going to get hit with a 30-month penalty period. But I got 4 more years. After 2 years, I'm still going to get a 30-month penalty period, but in 3 more years, I won't. If another year goes by, so I'm still going to get a 30-month penalty period, but after 2 more years, I won't. And when you finally get to 5 years, there is no penalty period because they can only because now if you apply for 10-Care and they look backwards, they won't see the transfer. Mm-hmm. So we have this look forward period. So I put this piece probably I put it in the trust because I don't ever want anybody to get it. The minute I put it in the trust, they're never going to. The only thing I worry about now is the penalty period.
Right.
Now, let's just say I go 3 years. 3 years, everything's going good. The goal was if I stay out of the nursing home or long-term care for 5 years, that property's protected. So I get 3 years, and unfortunately I have a stroke. So I drop the ball, I blow the goal completely, and I don't make the 5 years by having an untimely stroke.
Okay.
And it's a paralyzing stroke. When I come out of it, I rehabilitate, I need help with the activities of daily living, so I have to go into care. Okay, that's the scenario.
Okay.
So go into care, and the cost is going to be maybe $8,500 a month.
Mm-hmm.
And the cost is this: the cost is $8,500. That's the average around here, $8,500 a month. So the cost is going to the part that needs to be paid. You know, the TennCare would pay if they're going to pay is they get all my income. So let's say I have $2,000 worth of income, then they would pay the balance. They paid the $6,500. Now they actually don't pay that either because it's kind of like insurance money. You know, they don't pay the actual bill. They pay something less. But let's just keep the numbers straight for now, and that's how they normally pay. So if I go in, I got a question. It's like, okay, if I'm going to the nursing home with 3 years, if I file a TennCare application, they're going to hit me with a 30-month penalty period because they're going to look back 5 years and they're going to see that 3 years ago I put this $210,000 house into the trust.
Yes.
And they're going to say exactly what I said. They're going to, Stan, you're eligible, but we're going to impose this period because you've divested yourself of property in the last 5 years. And so the question is, now if I want to keep this property, I do not file a TennCare application. Okay? If I do, I have the penalty period. Now, I guess you could take the penalty period, and if you take the penalty period, then you just private pay or don't get care, right?
Mm-hmm.
So what we're going to do in this case, we would have put some property, possibly more property, into this trust, like in the form of cash or bank account money, CDs, investments, something like that.
Mm-hmm.
Now, we're going to take the decision to private pay for the next 2 years.
Yes.
We're going to get to 5 years by private paying. So at $8,500 a month, that's what, $102,000 a year, something like that. So we're gonna private pay. Now they get all the income anyway, so it'd be something a little less than that out of assets.
Sure.
And so we're gonna pay, $100,000 for year number 4, and then we're gonna pay $100. Now if we pay it with money, we can pay it for money that's in the trust. We don't have to take it out of what we're keeping for ourselves, but we can pay it out of the trust if there's money there. And if we would do a strategy like this to protect that, my advice would be we need to put some money in the trust in case we fall short. We need something to pull from.
Sure.
Other than the property that we're trying to save. And so then you private pay for the second year.
Mm-hmm.
Now we file the TennCare application because now they're going to look back 5 years. They're not going to see the transfer into the trust. We're going to be eligible. They're going to pay. And now we know that the property we put in the trust is going to be distributed at death to where we said it's going to go, to keep it in the family.
Sure.
And there's nothing can be done. We're outside the 5-year look back. We are in a creditor protection trust that we've successfully made the asset non-countable. It's forever protected. So in that case, there's some loss because we're paying private paying, but we're only out those 2 years of private paying. The difference is, had we not done nothing, everything's exposed. Okay, everything's exposed for the whole time we're living there.
Yeah.
If you get a stroke, or if you got a dementia, and you are actually there for a long time,
Right.
you can rack up a pretty good bill, and you can exhaust the estate that way. This way, we mitigate it. And again, that's just an example. It could be. We can manipulate those numbers all over the place, and sometimes it turns out to be a tremendous advantage to do it that way. The times it's not as big an advantage is if you put this property in trust and something happens very soon, 6 months to a year, and you're very early into the trust.
Yes.
Then we kind of reevaluate the whole thing and decide if there's a better way to deal with it. But if we can get halfway through this 5-year trust, we're usually in pretty good shape to stay with the trust. So there's all kind of strategies that we can do that are so much better than doing nothing.
Now, I may have missed this during what I was listening to there, but we put an asset in the trust, and let's say 4 years goes by, but then, it happens that I've got to go into long-term care. Do they still do is it just a 1 year that you're out at that point, or you know what I'm asking?
Yeah, I do.
Okay. Did I miss something there?
No, you got it all there. It's just not clicking.
It's not clicking.
But it's all there.
It's not clicking.
So good job so far. Let's look at it this way. And the best way to think about these things is go back to the fundamentals.
Yeah.
Okay. So let's fast forward to when you file a TennCare application.
Yeah.
Okay. Because we want to look at it from TennCare's eyes.
Yes.
Okay. So fast forward, you can't even file an application till you're in care. You
Okay.
can't. I couldn't file one now just to see how it would work out. You know, what I
Yeah.
mean, it would fail on step number one.
So I'm in care and I
Yeah.
file
Yeah.
for.
Hopefully, we're
10 years.
fast forwarding 20 years more.
Yeah.
Give you a longer period than that. Anyway, and you file. You say, you know what? You and your family say we need to file for 10 care to get the benefits. So we
Right.
file. The day they get that application, and you do it by fax, if you can believe it. 10 care still works by fax.
Yes.
But they fax it in. They get the tap. That is the beginning. That is day one of your 5-year look back period.
Okay.
Now, because when they talk about this look back period, it's a specific period of time, and for
Right.
you and me, it's a future event. Okay. Now it hasn't
Right.
happened yet, but when it does happen, when they get that application, what you have done is you have given them the right to look into your financial history for 60 months, 5 years.
Yes.
And I often tell people that's a jurisdictional time period. I mean, it's not 60 months in a day, it is 60 months. That's how far they can look. And what they're looking for is what we're talking about. Did you ever, a divestment, did you ever give anything away for less than market value? So in this case, in your example, they're going to look back and they're going to see that 4 years ago, you made this divestment.
Yes.
Is that within the 60-month time frame? The answer is yes. So they can impose the penalty period. And when they do the penalty period, if it's the $210,000 house and the divestment penalty divisor is the $7,000, it's a 30-month period. So they're going to say, Jeff, we got your application and you're eligible. We're going to impose a 30-month period because of what you did 4 years ago.
Okay.
So we don't want to do that. We're not going to file an application then. We know the answer to that question. It's like, why am I going to? It's like, okay, I'm in a nursing home. I divested myself of this property 4 years ago. Be kind of boneheaded of me to send in an application. I know they're going to impose a penalty period, right?
Yes.
I mean, it doesn't take a PhD to figure out what the answer is going to be. So what I'm going to do is I'm going to wait until when I file the application, it's 60 months and 1 day later.
Yes. I got you.
So
now.
I got to. I'm not going to private pay or do something else to get to 5 years.
Yeah.
And the closer we are to 5 years, the better that strategy works. So staying out of the nursing home is goal number one.
Sure.
That's the primary goal. Easier said than done sometimes. But I'm
Yes.
just saying, put it in. That's why it's good to do it when you're like 50 to 65 years old and you're basically still healthy, right?
Right.
And statistically, you got a 95% statistical chance of clearing the 5 years and being great. But anything can happen. We recognize that. Anything at any time can happen. But so the goal is to put it in there and stay the heck out of long-term care for 5 years. The second goal is get as far into the 5 years as we can. Now, how can we avoid that? Let's just take your example. 5 years, there's something wrong with you. Do you have some money to hire some people, or do you have enough family support to take care of you at home?
Yeah.
To limp through to this 5-year period. Now, I'm not talking about, when I say limp through, I'm not meaning low care. I'm
Yeah,
talking about
try to get by.
limp through this calendar year. Get to this point without going into the care, which is exorbitantly expensive.
Yes.
Now, it's still going to cost you to do it. It's going to cost your family members to do it. But, if you have let's say you didn't put $210,000 in this trust. Let's say you put $1 million farm into this trust. Something the whole family depends on. It's income producing. You see where I'm going, right?
Right.
We absolutely cannot risk. Now, that would trigger a penalty period that would exceed your lifetime.
Right.
A $2 million farm. You know what I mean? That's a 20-year penalty period, right?
Right.
So we don't, and there's no upper limit to that penalty period. So what we can do is we can if we can get family support, or maybe have some family support and some hired in
Sure.
home help, depending on your infirmary fees, you may be able to do some things for yourself. We'll just kind of get to that 5 year. Then we'll
Well, I
apply.
feel better now. It clicked finally.
Yeah,
what you're
yeah.
telling me.
And but it's a strategy. It's a thought through. Now,
Yes.
when you put the property in, let's say we back up 5 years and you're doing the trust now, I call it a 5-year look forward period. It's not the 5-year look back period because that hasn't started yet. But it's a period we use for reference to ask ourselves, where would we be if we applied today?
right.
And I look forward to where we are. Okay, I got 4 more years to go. Where would I be if I applied today? I got 3 more years to go.
Right.
And then that's kind of the way that looks. We start that time clock working kind of in reverse.
Yes.
But we get it under our belt. So when we hit the 5-year mark, everything in that trust, everything you put in that trust, we never have to worry about ever. No matter whether you go into long-term care or your wife goes in or you both go in.
Sure.
They cannot get at it. It's non-countable. We did that the day we put it in. And now they can't even impose the 5-year rule on us.
Right.
Another 5-year rule is a government-imposed time frame, and I can do nothing about that. I remember I told you it used to be 3.
Yes.
They changed it to 5 back in 2006 or 2005 but Tennessee adopted it in 2006. But it's way overdue. It is way overdue to change.
Okay.
You know, they're going to make it longer because when they increased it from 3 to 5 for the Deficit Reduction Act, it was not our deficit they were trying to reduce. It was government deficit. Now, when they make it 7 or 10, it's going to be a longer period of time where they can get after this property. Or
Do you see that coming? You see that coming?
well,
pretty soon?
I keep my finger on that pulse, and they talk about it from time to time, but it always kind of fizzles out. I really expected it to happen by now, but it didn't. So far, so good.
So far, so good.
But you know, again, these. Let me say something about this. When you say, "Do you see it coming?" We sort of have an advantage here in Tennessee. We would see it coming. We're not going to wake up one day and it's that way.
Yeah.
And the reason we worry about it is because, you know, you say, well, it's not that they can get at more property for a longer period of time. Because if they can impose the penalty period and not pay, isn't that just like them getting the property?
Sure.
It's money they don't have to pay, right?
Sure.
So it's the same thing. So,
Sure.
But here in Tennessee, you know, our laws go into effect twice a year, January 1st and July 1st. So if, let's just say, today, our Tennessee legislature debates, well, first of all, here's what has to happen. The Fed's got to modify the Medicaid Act, which is the federal program,
Okay.
to say we're offering that you adopt of a 7-year period or 10. Let's just say 7.
Okay.
And now it's up to the individual states to adopt that or not. They don't have to. As a matter of fact, the 5-year period, 49 states adopted it, 1 did not. The only one that didn't adopt it was California, but they're so screwed up that it sounds like an advantage, but it's not. But anyway, 49 states adopted it. And the way they do that is they make more Medicaid funds available to you. And the states will say, man, we can get more money from the feds to run our TennCare program. We'll do anything they say. And so they'll just blindly opt into it. Now, if you're a legislator listening to me, please listen to me. And don't just say, oh, well, we get free money, we're going to just do it. Think of what you're doing to the people.
Sure.
You know, talk to me or talk to somebody like me or think it through. It's anyway, I guarantee you if they do that, they will. That's just how it works.
Yeah, you would
Now,
think.
so Tennessee has to adopt it. So that takes a certain amount of time. So, but when Tennessee does adopt it, the legislature is going to say, okay, we're going to modify our TennCare Act to impose a 7-year period. And let's say they sign it all off. It goes through both houses, goes to the governor, and he signs it off next week. Everything's in place. Well, that law will not be effective until the next time Tennessee law goes into effect, which now would be January 1st.
Yes.
Or July 1st, but we're past July 1st, so it would be So if that happens, we can see it coming. And I will certainly be ringing the alarm bells to folks and say, look, now we got a window of time. If you get into one of these asset protection trusts, we can still avail ourselves of the 5 years because the law, when it goes into effect, it'll be for that 7 years from that moment forward.
Right.
So we can kind of see it coming here in Tennessee. But I'm telling you, don't wait for it because I don't know when it's coming. If it does come and I start telling people about it, I'm going to be overrun, probably. You know what I mean? Things are going to get hectic. Don't wait. I don't think they can do anything faster than that, but who knows? I mean, they're the government. They kind of do whatever they want sometimes. But they're going to change it. And if anybody's going to change it, it's going to be this administration because it's too much money to leave alone.
Yes.
You know, and so, you know, when you have an administration that does nothing but spend and give and hand out freebies, I mean, there is an inevitable result of that.
They're money hungry. They have to be.
Well, there's an inevitable result. And it's like, well, how do you know the result? Well, because you study history. The same thing has happened to every culture that has done this. It's doomed. It's doomed to failure. It will collapse. It has to. You can't create something out of nothing and not have a collapse.
Well, yeah.
So, I mean, so they're going to be looking for ways to fund, and that's a way to fund. And it hasn't been looked at since 2006. Does it sound overdue? It does to me. Yeah. I thought they would have changed it before, but they hadn't. I mean, I've been waiting for it. Let me put it that way. I'm waiting for that to shoot it out for years.
Waiting for it and watching for it.
Yeah, and they've talked about it a few times. It starts buzzing about it a little bit, but then it kind of fizzles out, which tells me there's a lot of people in government that use these kind of tools, and so they don't want to shoot themselves in the foot either, right?
Oh yeah.
So, so we'll see. I mean, right now it's still 5 years. There's nothing I can do about that. But we can plan around it. We can work with it. We can make the 5 years work for us sometimes. I don't have time to get into it, but maybe next week we deal with these Medicaid compliant annuities / gift theories, where we can take this penalty period, and instead of being in a "oh woe is me" situation, we can turn it around, put it to our advantage, and salvage up to 70% of all the property. There's still a little bit of, well, when you're single, there's still a little bit of loss, but we can salvage 70% of what we could, if we did nothing, would lose all. So, I mean, it's kind of a no-brainer, but we'll talk about it. And it's a little number heavy, so I kind of try to keep it as easy as I can with simple numbers, but we'll talk about that on the upcoming show.
Well, it's all about planning and strategy, which is where your expertise lies, and especially in this field.
And that's what we do at
That's what you do.
Pierchoski Estate Law and Pierchoski Elder Law. That's all we do. Is what we do: foundational planning, which is revocable living trusts and a special needs trust. We also do the asset protection trust for people worried about TennCare, and we do TennCare planning, whether it's pre-planning or what I was just talking about, crisis planning.
Yeah.
It's all part of your estate. It's all how do we mitigate or try to keep you to hang on to your lifelong wealth as much as you can, or do with what you want with it, like either spend it in your retirement years or give it to your kids as an inheritance. But it's your stuff. You've worked for it. You need to be the one deciding what's to be done with it.
Yeah,
not it taken from you for.
Yeah, every time I've talked with you, it just makes me think, that how much we really do need to strategize and plan and have a plan in place ahead of time, and not wait until you're in the crisis mode.
Right, because then people start trying to think of these strategies that are less founded in law, like the divorce strategies and stuff. What we do, everything we do is founded in law. When they ask me, what'd you do with this client, I'm more than happy to tell them. I'm not hiding anything. And
Right.
I'll say, here's what I did. Here's where it went. Here's the authority in the statute that says I can do that.
Yes.
So there you have it. Basically, here's the authority that says there's really nothing to do about it. So what's your next question? I mean,
Yes.
It's really a simple process when it's like that. I mean, we're
Yes.
backed up by the law. I'm backed up by the court cases that enforce it that I talk about from time to time. We're really in a rock solid position.
That's great.
And that's the way to do it. So, all right,
Very
listen,
good.
we are running out of time, and
we got a couple minutes.
Amazing how that hour goes by so fast. But listen, let me just remind you of my next seminar coming up. At Pierchoski Estate Law, Pierchoski Elder Law. We're holding it right here at the WLX radio station in the back of the building, the Country Cafe. We're going to do that on September 16th, and that's a Saturday. Most of my seminars coming up for the rest of the year look like Saturdays because it just seems to be most popular for people to attend.
Sure.
And we like to accommodate. So we do those at 10 o'clock in the morning. We're doing that one September 16th, 10 o'clock in the morning, right here at WLX. So if you want to get on that list, call me at 931-363-7222, or go to my website, Estate Plan Stan. That's Estate, ESTAT, planstan.com. You can see my calendar. You can RSVP from there. Or if you have a question, you can email me or you can call me and schedule one of my 15-minute phone calls where the girls will put you on the schedule for me to call you. And when I do, that time will be dedicated to your question. My time and attention will be dedicated to that. And again, they call them 15-minute phone calls. I always call them 15 lawyer-minute phone calls.
Very
you
good.
can't do much in 15 minutes, right? So,
That's
but I'm
right.
more than happy to do that if you want to schedule those. So, give us a call. And if you want to talk about any kind of estate planning, give us a call. We'll talk about it. We'll evaluate your situation. I'm sure we can. You'd be amazed at what we can do.
EstatePlanStan.com is a good place to start. And, of
Yep.
course, the office number again, 931-363-7222, located in Pulaski, Tennessee.
My office is right there on the square in Pulaski. You got to be located somewhere.
Got to be somewhere.
But we go everywhere.
You go everywhere.
Like I said, we had a seminar up in Franklin and had a great crowd. And whenever I have seminars, my calendar gets a little busy afterward.
Yeah.
Because we offer price incentives for people that come to the seminars and pre-educate themselves.
All right.
And so we're having another one next month. And this one seems kind of quick to me, but the girls must have had some reason to. They have to deal with the venues, and maybe there's some reason they had to do it that soon. But we usually have a little longer time between them. But I just go where they tell me to go.
Very good. Estate Plan Stan, everybody. Until next week, my friend, I'm looking forward to it. We'll dive into it again next week, next Friday. Check it out online at WDXE Facebook page. and be looking for it. You can watch it again right there anytime you want to.
You can go back and review it if you want.
That's right.
All right, always a pleasure, Jeff. Thank you.
Thank you, man. God bless.
This is WDXE, W287AA, and W237FD Lawrenceburg. Broadcast services of Prospect Communications.